Welcome back to our show, your show, Let's Talk Stocks. In studio with us this morning is Mr. Chukwuemeka Cameron. Now he's founder of Design Privacy as well as a consultant on issues relating to the Data Protection Act and an attorney at law.
That is correct,
All
sir.
right. So welcome to the show.
Always good being here.
All right. So the Data Protection Act is now live. It's now in force, isn't it?
As of December 1, 2023, it's in full force and effect, save for the Information Commissioner has said that she's going to suspend her powers to, or not use her powers to lock up people for the next 6 months. But outside of that, it is in full force and effect.
Walk us through initially, the initial stages of what companies were required to do to be compliant with this act.
So, as of December 1, the legislation says that you shall not process personal data without having registered with the Information Commissioner. Registering with the Information Commissioner just does not mean submitting your name and the name of your business and your TRN number. No, it means submitting an inventory, basically, of all the personal data you have in your business and why you have it and who you're sharing it with and how are you protecting it in general. That should have happened by December 1. Failing to have done so by December 1, the legislation says that it is a criminal offense. Because remember, we are implementing a scheme from scratch. And so for the Information Commissioner to be able to monitor and safeguard the rights of the data subjects, our data, she needs to understand who has what and what are you doing with it and what are you how are you protecting it. So the idea was really just to develop a baseline so she can effectively monitor. So that's one thing that you should have done. And it is in relation to that she has given a grace period. So if it is you have not yet registered, she will not be enforcing that, the powers of sanction that she has in relation to that.
And this 6 months period started on December 1?
So, that is what the Minister of Digital Transformation said. How practical that is, I question, because the reality is the Office of the Information Commissioner is not yet in a position to receive registration particulars, and the regulations that identify the details and how it is to be done have not yet been promulgated. So while that was said, I am not of the view that the 6 months period can start to run as yet, but the minister said it started to run as of December 1.
All right, which means interesting.
There's uncertainty in the market.
Are there any companies which should have been compliant in terms of registration?
So what the Information Commissioner has done as a halfway house is she requires you to register your name and open an account with her office. So it is expected that all data controllers would open their account on their website.
So at least the Information Commissioner would have had their names and their accounts registered on their on her Information Commissioner's website. But in terms of the execution of that process of registration, the Commissioner's office can't handle it just yet.
I wouldn't say can't handle it. It's not open to the public to execute as it, let me say it like that. And it is subject to the regulations.
Yes.
And that is a function outside of the Office of the Information Commissioner.
So according to the regulations, what is actually required, we might have a little gray area in executing it.
Correct. However, what I've heard in the market is that medium-sized to smaller firms, having heard of this 6 months grace period, they have said, oh, so we don't have to worry about it anymore. And one, or we have enough time to get it done. That's a mistake. That's a wrong approach, because it will take at least 1 year for a bigger organization to collect that inventory of personal data that you have to submit.
But explain to me. So when you said they should submit the inventory of of data that they have on people that they're processing and so on, what exactly are we talking about? How does that inventory look?
Okay, let's make it very practical. So let's say that this is a media house.
Yes.
Do you think you have an inventory of personal data that you process?
Of course.
Okay, so have you contemplated that when I entered this premises, your security guard asked me my name?
Yes.
When I come in, well, before coming in, your producer would have had my number and would have contacted me and spoken to me.
Yes.
Your suppliers that provide you with all of this equipment, you have contact details for them. All the persons that you get leads from and your news information from, you have their names and numbers sitting down. You have your employees' names and numbers and their health records sitting down. So in every business, as innocuous as it may seem, you process personal. So you need to you have to be very meticulous and say, okay, what information am I really collecting? So if you look at your business and your business processes and walk through that business journey, you'd realize every step of the way, I am collecting a lot of information, and that is what the Information Commissioner wants.
So is there any information on the percentage of companies who are actually processing people's personal information that have actually attempted, well, or at least, as we spoke to, given their names and stuff to the Information Commission? Do they have any idea?
Very interesting question. And we ought to know that. The reason why I say you ought to know that, or we ought to know that, is because the Information Commissioner is required to maintain a public register. Because it's not only for her to be able to monitor. It is for persons who want to validate the trustworthiness of an organization in relation to how you are processing my data. I want to know if you have registered. So the law does require her to establish a public register. So ideally, right now we're supposed to be able to go on our phone or go on the website and see who has registered. Well, it really speaks to publishing so that is interesting, and I'm going to invite you to call the officer of the Information Commission and ask her about that.
You might have to bring her here to come do an interview.
Definitely. No, man, there is a great need for education, and I'm sure she would jump at any opportunity to educate the public.
Absolutely. All right, so let's look at the implications for companies under this new legislation. Not registering, which means you would not be compliant.
So so forget about the fines that are associated with not registering. What you want to be concerned about is the power of the Information Commissioner to tell you to stop processing personal data. Yes. If she tells you to stop processing personal data, that means you cannot call me to do an interview. That means your business closes.
Exactly.
So, and as you may not have thought about the importance that personal data plays in your business, but if she tells you to stop processing personal data, that is it. And you have to do. She can do so and say, until you satisfy me that you have implemented the requisite data processing standards, I'm not allowing you to process any personal data. So the implications are significant, but more so, outside of the sanctioning, is how do you maintain a relationship with your customer? Every month we hear of a significant data breach where my information, your information is in some dark web or something has happened to it. We are getting more concerned about it. We are aware of identity theft. We all know someone whose bank account has been hacked. We don't want that to happen to us. So I am personally getting, outside of the fact that I'm a privacy practitioner, I want to know that if I'm doing business with an organization, they are mindful of how they are using my information, because they can be exposing me to harm. So failing to comply or demonstrate compliance with the Data Protection Act does impact on their brand image in the face of the public. You do want to position yourself as a trustworthy, somebody who respects you and takes not only your money seriously, but takes your privacy seriously as well.
And this is for all companies, large, small, medium.
Churches, schools, charities.
Charities. That's interesting. So churches would interesting. Churches are required to register under the Data Protection Act.
And not the head office church, all churches, all schools.
That's quite interesting.
It's quite a lot of personal data that they are processing.
Yes, you're correct. Has there been, I know there have been information out there, there's been certainly much attempt at, educating business operators and so on. But from where you sit, Sir Cameron, do you think that the charities are fully aware of their responsibilities under the Act? Churches,
the reality is that businesses are not fully aware of their responsibility under the Act, and I'm not satisfied that the effort to drive that awareness is sufficient, has been sufficient. The reality is, well, in my mind, there ought to have been a much greater push than the public awareness campaign that was put behind NIDS. Everybody knows about NIDS. NIDS, but the Data Protection Act affords us rights. And the Data Protection Act is what enables there to be a NIDS. So if it is that much more important than NIDS, the public awareness campaign ought to have been that much greater. So in the same manner in which you see we want to amend the Constitution, and they're trying to have this, or even the introduction of the Data Protection Act, when they had the initial consultations, it had to be, still has to be a massive campaign, because here, Jamaican citizens now have the benefit of a right that we did not know that we're aware of. And if we're speaking about digital transformation, it puts the citizens in a position to hold the businesses accountable and vice versa. So,
speak to me a little bit more about those rights, because a lot of the emphasis has been on registering and ensuring you're compliant, and what will happen to businesses who are not compliant. But you're saying, hey, citizens, consumers, the persons whose data you're processing has been accorded certain rights.
Constitutional rights.
Constitutionally, under this act.
Correct. No, sorry. Under the flowing from the NIDS decision, our Chief Justice declared that we have informational privacy rights.
Okay.
And it is the Data Protection Act that creates that framework to protect it and enforce it. So under the Data Protection Act, you and I have the right to pick up the phone, send an email, and demand that you tell me all the personal data you have on me. You have 30 days to reply to that. Okay. Failure to reply to that does expose you to criminal sanction. Okay. Before you can protect personal data, before I can protect how you use your data, how you use my data, I need to know you have it.
That was Mr. Chukwuemeka Cameron, of course, chatting with us about the Data Protection Act, the new Data Protection Act, all the things that you and your organization need to know about the act and how to be compliant. Very, very important. We couldn't have done it in one show, though, so stay tuned for part 2, where we'll have a continuation of this discussion. Until then, as we always say here on Let's Talk Stocks, we give you information to make better financial decisions. Come back with us tomorrow morning at 9. Another informative program lined up for you.